All right, please be seated. All right, the next case we'll take up will be Ivan Lefkowitz versus Quality Labor Management et al.
Thank you, Your Honor. May it please the Court, Usher Larry Brown, attorney for Mr. Lefkowitz, the appellant. We did file a notice that I would be making the oral argument. It didn't appear on the docket sheet that I saw today.
Okay. How much time would you like for rebuttal?
5 would be more than enough, and I'm not sure that I'll take up too much time on my argument unless you have questions. I think this is a very narrow, discrete issue on whether the trial court abused its discretion in denying Mr. Lefkowitz, who, by the way, is here in the first row there to my left. And Mr. Lefkowitz is a 30-year-plus transactional attorney, not a litigator, but specializes in estates and corporate law matters. Whether the trial judge abused his discretion in not allowing Mr. Lefkowitz to intervene as a party in the quality labor case against Brian Newton et al. And this is a little bit outside the norm because we are attempting to intervene after the final judgment was issued in the case. And we also believe we were denied due process by the way in which the matter was handled. And if I could just address briefly the procedural history, Mr. Lefkowitz loaned Newton $250,000, and he secured that loan, it was a business loan, by collateralizing Mr. Newton's interests in 4 partnerships, and some of them are limited liability companies and such, but we refer to them as the 4 partnerships, and they're identified clearly in the record. The UCC1 is also in the record, and it identifies Mr. Lefkowitz's percentage interest in each partnership. The $250,000 loan was collateralized, and the UCC1 financing statement was recorded with the Secretary of State as required by law in September of 2010. And there was, and there has been and continues to be, litigation between Mr. Lefkowitz and Mr. Newton and another intervenor in his case, Mr. Lefkowitz's case, which was recently, as was pointed out to the court in the record, it's been transferred to the business court recently. There is another intervenor in that case, Integrity Hauser, and as you can surmise from the limited record, including the transcript of the hearing, Mr. Newton had pledged the same asset, arguably, to multiple creditors. We take the position we were first with a duly perfected security agreement. The second agreement that Mr. Newton made did not occur until December of 2013, which is 3 years after the perfected UCC1 security interest becomes of record. And what occurs in December of 2013 is they file, Quality Labor files the action against Mr. Newton, claiming that because of a breach of an oral agreement, Mr. Newton is indebted to him in an amount exceeding $450,000. And within just a few days thereafter, on December 9th, 2013, we have miraculously presented to the circuit court, in this case, Judge Egan, as I recall. I did not note the judge's name.
Judge Egan.
It was Judge Egan. Thank you. I wasn't sure if I remember that correctly. I appreciate that, Your Honor. What's presented on December 9th, just a few days after filing the complaint, is a consent agreement whereby Newton consents to judgment against himself, a default judgment. He consents to charging orders being issued, and then charging orders are issued. And so Mr. Lefkowitz only found out about this, as was suggested by Attorney Greg Johnson during the hearing below, that the partnerships, the general partner or counsel for the general partner, contacted Mr. Lefkowitz and said, we are presented with these charging orders, and that person had been escrowing, the attorney had been escrowing all the distributions from these partnerships so that they're now well over $100,000 just sitting there in an escrow, waiting for Mr. Lefkowitz to conclude his case against Mr. Newton and now the intervenor in that other case, which is Integrity Hauser, which had a judgment entered against Mr. Newton subsequent to Mr. Lefkowitz's perfected security interest. And those charging orders were presented. Attorneys in my firm, as indicated in the record, contacted Mr. Nelson on behalf of Quality Labor and said, you know, we have a UCC1 which is recorded a record for 3 years, you know, since September of 2010. Can we get an order allowing us to intervene or get some relief? And we were denied. So on December 12th, Mr. Lefkowitz filed a motion to intervene, which is 3 days after the entry of the charging orders and the default judgment, all with the consent of Mr. Newton. And as Mr. Johnson argued to the trial judge below, it's very curious that we had been in a very difficult litigation with Mr. Newton for several years, since 2011, yet through some magic, it's very curious that Mr. Newton has rolled over like a panda bear when it comes to consenting and agreeing to the charging orders, and he did it very promptly. And I'm sure we can all understand and reach reasonable inferences as to what could have occurred in the subtext to all this. But fortunately, the party holding the escrow called us and said, you know, we're being presented with these charging orders. So failing to get relief from through voluntary negotiations with counsel, Mr. Lefkowitz promptly, within 3 days of the charging orders, filed a motion to intervene. As stated in the record, we tried to get hearing time before Judge Egan. Judge Egan wouldn't, his judicial assistant wouldn't give us hearing time, so we filed it ex parte just to get in front of the judge. And you see in the transcript what occurred. The judge basically said, I haven't read the motion. I'm denying the motion, even though I haven't read it, and I'm going to give you, even though I'm denying the motion, I'm going to give you 7 days, which ended on Christmas Day, December 25th, whereby the charging orders will be stayed for 7 days, and he invited us to take it to the 5th DCA, where you gentlemen would read the motion, presumably, and make the decision for him. And you did. We filed an emergency motion for stay, and on, I believe it was December 23rd, you did issue a stay, and here we are today. I think that under these facts and other facts, which I don't need to belabor, but under these facts that I've mentioned, it's in the interest of justice, and justice should require that we be allowed to intervene before the distribution of the proceeds occurs. We cited to a 5th DCA case, the Humana Lawton case, which vacated a denial of an intervention after judgment, open quotation, at least to be heard before there's a distribution, end quotation, of the proceeds. And that's precisely what we have here. We cited to the court the Blossom case, where the First District Court of Appeal held, and we think it's good law throughout Florida, that if you have a perfected security interest under Article 9 of the Uniform Commercial Code, that is superior to subsequently created and perfected interests of whatever type. They argue the lease pendens statute 48.23, and I think that's a misreading of the statute, because just in my 30 years of experience, I've never seen a pure Article 9 security interest against personality that's unrelated to being a fixture to real estate, or, for example, with a hotel or a motel that could be subject to a mortgage. You have, you know, beds and furniture and television sets, and in that case you'll have a security agreement in conjunction with personality that's also part of a real estate transaction. That's the only time I've ever seen a lease pendens recorded, and curiously, they cite no case for the proposition. And it's probably because if you look at the lease pendens statute, it says that the purpose of a lease pendens is to give notice of an interest, and if the interest is not based on a duly recorded instrument, then the trial court can treat the lease pendants as an injunction and can require posting of a bond to continue it. So I see nothing in the statute that says if someone has perfected an Article 9 security interest in personalty, and these partnership interests are personalty, they're not real estate, that you must record a lease pendants in order to protect yourself from things such as what occurred here. So we would hope that in the interest of justice you would allow us to intervene. This is $250,000 loaned and in consideration of a perfected security interest, and if that is deprived from us, we've been deprived of a valuable property interest without due process of law. And I think in your decision, if you choose to do so, it seems to me that directions and instruction could be made to the court below that if it is found that Mr. Lefkowitz has a properly perfected Article 9 security interest as of September 2010, it would be necessarily superior to and have priority over.
That's not the issue really before us.
No, it's not. It's not. But I mean, I'm hoping that some guidance could be given, mainly because of the reaction that we received in the trial court. It would be helpful.
But that, you know, without being overly critical, it seemed that you know, this is a circumstance that a group of lawyers comes into ex parte on a very complicated commercial matter, and that perhaps it might have been a bit overwhelming, you know, to the trial court judge because of time constraints.
Yes, sir.
But I don't know that signals anything long-term in terms of the treatment of the case. And if you've been moved to the complex business litigation, you're going to have judges who theoretically have the more expertise and the time to give the case the attention that it deserves.
I appreciate and agree with your comment, Your Honor. The case Mr. Lefkowitz initiated, because of the experience in that case, we did move to the business court, and it's set for trial in front of Judge Blackwell, and we're getting precisely the type of understanding you need in a complex business case. This case that we're here on today, quality labor, is still not transferred, so that would be an issue for us then with the trial judge, whether he would allow us to move if we're being permitted, because when you grant us intervention, or the trial judge grants, you have to specify for what purposes we're allowed to intervene, and I would hope that one of the purposes would be to move, if appropriate, to transfer to the business court, so then we could ask Judge Blackwell to perhaps consolidate.
It's an administrative function of the circuit court.
Yes, sir.
But as far as, I mean, what are you seeking in the intervention? Just for the trial court to determine the respective priorities between you and the appellee in this case?
Yes, because their charging order has the effect of taking immediate cash.
Right, but is there anything besides determining priorities that you're requesting?
I think is an ancillary issue, and the answer is that's the primary issue, Your Honor, is a priority. But there's also the subsidiary issue that in addition to the security agreement, and there's a pledge and an assignment, so we would also argue that by virtue of the default, the asset simply isn't there. It needs to be assigned retroactive to the date when it should have occurred, back when there was a default, and Mr. Lefkowitz tried to make a demand for the interest to be assigned as agreed. He had Mr. Newton and his wife, Michelle Newton, sign pledges and assignments, you know, that if you defaulted, the interest itself, not just the income until I'm paid, the actual interest were to be transferred. So that's slightly different than priority, but those are the two issues, Your Honor, that we would need to have.
Well, they can't have a priority if there's no asset for it to attach to. I mean, your argument essentially would be, if they have any interest, we're first, they're second, but they don't have any interest because there was no asset for them to attach to.
It's in the alternative, Your Honor. We think that because Mr. Lefkowitz in the transactional documents, and it is important, there's no doubt that the $250,000 was loaned. This is, to protect himself, he covered both bases. So in the alternative, it's one or the other. Either we have priority or that asset should be conveyed to us effective with the date in the assignment documents. If I've answered your question sufficiently, I have nothing further. If I could reserve, I don't know that I'll need 5 minutes, but if I have that amount of time, I'll take it.
You have 5:33 left.
Thank you, Your Honors.
May it please the Court, I'm Sam Nelson. I represent the appellee, Quality Labor Management. The trial court simply didn't abuse its discretion when it denied appellant's motion, its post-judgment motion to intervene in my client's simple collection action. You've seen the cases in my answer brief that post-judgment intervention is extraordinary, it's disfavored, it's generally not allowed with very few, very narrow exceptions.
Let me ask you, would they have had any right to intervene pre-judgment? Because if I understand the landscape here, your client brought, as you said, a simple collection action. It wasn't directed to specific collateral. So the effort that you're making to attach the funds that are held in escrow that have been talked about earlier, none of that occurred until you got a judgment and then began to exercise collection remedies. Is that correct?
That's correct. There's only...
How could they have either anticipated or had any right to intervene up until the time that you try to put the grab on the same asset that they're claiming?
And you've actually made the exact point, Your Honor. If you allowed every potential judgment claimant to intervene in every other collection claimant's case, just in case they were fighting over the same assets, it would be chaos. That's one of the reasons that they...
That's your argument here, chaos theory?
Amongst others. The other argument I make is they have filed a complaint back in 2012 for foreclosure of their lien on this personalty and for a declaratory relief establishing priorities. The Liz Pendon statute is clear. It applies to lawsuits regarding personal property as well as real estate property, real property. And in 2009...
I mean, I can remember I wrote an opinion on Liz Pendon.
And I argued that in front of you, Your Honor.
Mm-hmm. I don't remember whether we agreed or disagreed.
We did.
But, you know, Liz Pendon's doesn't create any interest in property. It simply puts parties on notice of someone's claim.
Yes, but you also wrote in your opinion in ad heen that Liz Pendon's is substantial and procedural. It is a substantial non-suit statute.
Yeah, but that case dealt with a specific Liz Pendon statute that said if after the filing of the Liz Pendons you don't do something within 20 or 30 days, you're out of luck. That's not the sort of Liz Pendon statute that we're dealing with here.
Your Honor, it is the same statute. It's a different section. In the section that we're dealing with here, instead of non-suiting a claim after somebody fails to intervene within 30 days, this non-suits a claim if somebody who brings a claim where a Liz Pendon should be filed, as they did, and they failed to bring it, if they do not record a Liz Pendon's, anybody like my client who obtains an interest in the same personalty during the pendency of their litigation obtains that personally completely unencumbered by their claim. If I can read the section to you, Your Honor, it says, any person acquiring for value an interest in the real or personal property during the pendency of an action described in subparagraph 1, and that's their action on the personalty, shall take such interest exempt from all claims against the property that were filed in their action by the party who failed to record a notice of Liz Pendon's.
UCC filing then becomes meaningless in your view.
Actually, Your Honor, this would include not only UCC-type liens, but mortgage liens on real property. It would allow anybody on real or personal property. In 2000, the problem that is created here is you have multiple entities that are trying to go after the same assets. The legislature...
You're not going after that asset until post-judgment.
Yeah, of course, Your Honor.
And so how do you acquire an interest in that asset for value? When I think about the use of the word for value in there, I think about BFPs, bona fide purchasers for value, innocent purchasers who plunk out money, and don't get clear title. How are you number one, how did you put out any value for this asset, not in general to the people that you're communally suing, but for this asset, how did you put out value? And more specifically, how are you a BFP compared to them?
Your Honor, this is lien versus ownership interest. The Liz Pendon statute in this case is dealing with my client's lien, so BFP doesn't exactly apply. But regarding the of value, I have a judgment that a circuit court in Orange County has ruled that Mr. Newton owed my client $450,000 and gave my client a judgment lien. There's only one way to perfect a judgment lien on partnership interests and limited liability company interests, and that is to get a charging order. Recording the judgment doesn't do it. Docketing with the Secretary of State doesn't do it. My client did, in essence, the only thing they could do, which was go out and get a charging order, which is the normal course. Now, had they recorded a lis pendens, as the Florida legislature required them to do beginning in 2009 when they amended to add this section to the lis pendens statute, had they recorded a lis pendens, I would have had a duty within 30 days to intervene in their case, and their case is a priority case. Our case was a simple collection action. Their case, they're fighting over priority. We would have been required to intervene within 30 days under 48.232, but they didn't record a lis pendens. So now we have the problem. They have their lawsuit, I have my lien. That is why the legislature in 2009 put this penalty, and it's a fairly harsh penalty. They included section 48.232B2 as a penalty for people who are litigating priority over real or personal property and who do not record a lis pendens, because it sticks people like my client. My client's just out there without a lis pendens, and there could be competing rulings from the courts. That, as a result, the legislature has determined that if you don't record a lis pendens, basically whoever acquires their interest, be it a judgment lien or any kind of legitimate interest in property, that's too bad for you for having failed to record a lis pendens.
How do you deal with the National Bank of Sarasota case where they say that the UCC perfection scheme is not subordinate to the doctrine of lis pendens?
Your Honor, that case was entered in 1976. In 1976, the lis pendens statute did not have this section in here. It is clear that the legislature, in passing this penalty, has abrogated or overruled that case from 1976.
What's the purpose of the UCC perfection scheme? I
It
mean,
is
why do they file the UCC 1 notice? What's the purpose of it?
It's to perfect a lien. It gives a uniform system so people know how to perfect a lien.
Right, well, it perfects the lien, but what else does it do? It gives notice, right?
It sure does. The same way that you perfect a mortgage on real property.
All right, so in essence, you're saying they had to give notice twice?
In essence, I'm saying that the legislature...
You're saying that they had to give the UCC 1, that's insufficient, they had to do lis pendens, but the purpose of both is to give notice.
Yes, they have to give notice first of the lien, but then they have to give a second notice. They have to invite my client to the party. If they're having litigation, they have to give notice to the world, hey, we're litigating over the priorities or who owns this property, and you need to come and figure that out in our case.
What if they never file the case?
Pardon?
What if they never file the case? Doesn't their UCC 1 interest mean something?
Yeah, then this wouldn't apply.
Well, what I'm saying is, say they had not sued the common debtor here, and they had a UCC 1 security interest, and now you sue the debtor, and you prevail, and you get a judgment.
Yeah, then the UCC, the lis pendens would not
So what I'm
apply.
saying- So you're saying the UCC 1 would be worthless then?
No, I'm saying the UCC would be fine, assuming, now, Your Honor, just so
in other
we're
words-
clear, their UCC, they
so
do
in
not
other
have an
words, they
interest.
lost- Hold on, so in other words, they lost the benefit of their UCC-1 security interest filing by filing a lawsuit?
It is. It's a harsh penalty, Your Honor. Often, when you don't do what the legislature tells you to do in a statute, it can have negative consequences for you. And in this case, it allowed my guy to jump ahead of them as if their UCC never existed. And it's just a penalty because they failed to do what they were supposed to do. They were required to first give us notice of a UCC interest, but secondly, they're required when you have, and this is from 4823-1A, an action in any state or federal court in this state operates as a list pending on any real or personal property. It includes personal property. Under 4823-2B2, if they don't record their list pendants, they are penalized. If they do not tell the world that they're fighting over this property to invite anybody else, and there may be many more people other than my client who, for whatever reason, don't know, if they don't invite people to this lawsuit of theirs,
You should have known based upon the UCC filing.
but they wouldn't know about the lawsuit. They would not have any way of knowing that Mr. LEFKOWITZ is trying to take the property. What they thought was the Newton's property is going to become his.
Their filing of a lawsuit changed the fact that they have given notice to the world, in essence, that they have a secured interest in this property.
It doesn't. All it does is they fail to tell the world, as the Florida legislature requires, that they're trying now to take that property away from the person who they just had a lien before. Now they're seeking to foreclose. And just like in a mortgage foreclosure case, if you do not record a lis pendens and you're foreclosing a mortgage, presumptively your mortgage was recorded and you've told the world you have a mortgage lien. But if you do not do a lis pendens, other people can innocently, like my client, go in there and obtain an interest, and that's inappropriate. That is
You
why,
can go in and innocently buy an interest,
or give a second mortgage.
or maybe give a second mortgage, but again, they've given value. There's new value there that they can claim, well, we were innocent, we wouldn't have done this. I don't see how anything that your client did would have changed, other than maybe he said, well, I wouldn't have brought the lawsuit if I thought this wasn't there. But I don't see how they're innocent or that they've been damaged in any way by the lack of a lis pendens.
I would argue, Your Honor, that a valid judgment from a circuit court in Central Florida is a good lien, and that there's nothing inappropriate about it, and that it's valid. And that the value has been established by a court of competent jurisdiction that the
Of course,
money
that
was
doesn't
owed.
address their argument, their subsidiary argument, which, and I guess what we're really talking about here is, do they get the right to make the argument, not whether it has any legs, but their subsidiary argument, which is that they essentially acquired title to these assets upon the default, so there's nothing for your charging order to attach to, that the escrow agent should have coughed up the money and that these assets should have been transferred over. I mean, aren't we really just talking about whether they get the right to make those arguments as opposed to whether those arguments have legs?
We are. And the reason that we're talking about the fact that the lis pendens statute would even preclude it if they said they had an ownership interest, and the fact that Florida law is very clear that you simply don't get to intervene post-judgment, except for in very exceptional cases. The whole reason we're talking about that is because the standard is abuse of discretion. You do not have an absolute right to intervene. Florida law is clear.
If we affirm the denial of the motion to intervene, and you go and your client seizes the assets, but their arguments are correct, can they sue you and recover from your client?
Not only could they, Your Honor, I've already intervened in their case. I'm fighting this argument where it should be fought, in their case. They didn't bother to join me, even though they knew I was out there. I had to file a motion and have a hearing to even intervene in their case, which they opposed. But now I'm there. I'm in their case making the substantial argument They don't have a right to come in my collection case post-judgment and try to make arguments in my case. Their case is the case where the priority is being determined. They are injecting an entirely new issue into a collection action here. My case was nothing but a collection action, truck care one.
We don't know what your case, you characterize it as such, but, it's got a feel to it of almost some collusion involved.
I can assure you that Mr. Newton owes my client, or his companies owed my client significantly more than the judgment amount. And that the fact that they settled.
The issue is whether we allow this to be ferreted out, in at proper time, because I don't know what happened. The question is, do they get to litigate the issue?
And Your Honor, if they want to litigate that issue, I have intervened in their case regarding the priorities and the validity of the liens. That is where it should be litigated.
In the meantime, the funds are gone.
Your Honor, there's a pending case that my client is a party to. If they ask Judge Blackwell to somehow stay my client.
Do you object to the stay in this case?
I
At
would.
every level?
Did I object to the stay here? Absolutely, Your Honor. And I would object in their case as well. But I'm sure you all know Judge Blackwell. She will hear the facts and she'll come to an appropriate ruling if they ask for that stay, which they have not.
Bottom line is, both sides are claiming that the common debtor owes them a bunch of money. And there's some property to help pay off any of those debts. And they're arguing that let's keep that property held in trust until this is determined. And you're arguing, by opposing all the motions to stay, that you want to hold all the money first and then we'll argue.
Absolutely, Your Honor. My judgment is valid. I have a circuit court that has ruled that
their UCC1 interest may well be valid too.
I'm here to represent to the court that their interest has not been validated by court.
The opportunity to argue that.
I'm aware of that, Your Honor. They've been in litigation now for over 2 years, and they still haven't gotten a ruling saying that they have any interest at all in the property. And
I'm looking at the Adhin case now, and understandably it deals with Section 1B, but it says, Section 1B bars holders of unrecorded interest in the property from enforcing their interest against the property if they don't intervene in pending litigation within 20, now 30 days of the filing and recording of the LP. But they have a recorded interest. I mean, the outcome of that case would have been completely different if the folks in the case that the Adhin versus First Horizon case, if they'd had a recorded interest.
But you've got it reversed, Your Honor. In this situation, they're trying to intervene in my case, which is not a case regarding real property. It's just a collection action.
Yeah, but
it should be looked at from my client's.
You've got a charging order that gives them the ability to put the grab on funds that they claim that they have a pre-existing recorded interest in.
Your Honor, and had they filed a notice of lis pendens like they should have, they're doing the foreclosure action, I would have had, the minute that I got my client's interest in that property, the minute that the judge signed that charging order, I would have had 30 days to go intervene in their case. And if I didn't, I had to live with whatever. If they were successful and foreclosed, my client would have had to live with it, just as in the Adhin case. But they did not follow lis pendens.
We say it's a substantive non-claim statute that automatically bars enforcement against the property by the holder of an unrecorded interest after the prescribed time period is run. Isn't the word unrecorded interest significant? They have a recorded interest.
Sure.
Reportedly have a recorded
But it's really, we're not looking at their interest, we're looking at mine. There's been no lis pendens filed, so the 30 days is not relevant. They didn't file one. And there's not one filed in my collection action. But had they filed a lis pendens as they were required, I would have, with my unrecorded interest, would have had to go and intervene. I would have. My lawsuit's a collection action. It's not really relevant. We weren't discussing priorities or anything like that. We're just trying to collect a judgment.
None of that became relevant until it was post-judgment. So as far as the propriety of intervening post-judgment as to pre-judgment, I mean, I think the trial judge would have been proper in excluding it pre-judgment, because you could have gone out and gotten a lot of different assets if there were any. Post-judgment, now, now that you're squabbling over the same asset, it seems like if they're entitled to intervene at all, it could only be post-judgment.
But, Your Honor, this was simply executing on a judgment. This is not, my lawsuit was a collection action. It was not regarding any priority. It is their lawsuit.
Yeah, but you're trying to execute on an asset that they have a recorded
So
interest in.
if you had a judgment against Judge Evander, like many people probably do, you went out and tried to grab his car that has a lien on it to, Honda Finance Company. You're not suggesting that because Honda Finance didn't file an LP, even if they've got a pending action, your position is that you would be able to beat, if Honda's suing him on that secured note, your argument is that you would beat Honda because they hadn't filed an LP.
Absolutely, Your Honor. And it's only because the legislature put a penalty in the statute.
That's a surprise to me, and I think a lot of folks. But it's an interesting
I would encourage you to look at that section. It's a penalty. That's all it is. It's harsh. I will grant you that it's harsh. But it is designed to make people, like in your example, Honda, if they're going to go seize...
The Florida legislature, under your view, has now completely turned security law upside down.
In situations where people fail to file lis pendenses when they're collecting, I mean, the statute is very clear.
Just so I'm clear, in the same scenario, if Honda had that same perfected security interest but hadn't gotten around to suing him, you'd be out of luck.
Well, I mean, there would have to be a lawsuit. We would have to fight over it, of course, but yes.
The problem is it just doesn't pass the common sense test. But, the legislature doesn't always have to do things that make sense. But
It's a clear penalty.
Look at it.
All right, thank you. Time's up.
I think the questioning and the answering, may it please the court, thank you for a brief rebuttal. I think the questions and answers that I've just listened to illustrate the horribly bad public policy implications of their argument, because that's how, in fact, as I was preparing for this, I was thinking of the car example. That's precisely their point, is that...
Were you thinking in terms of me being the debtor?
Oh, no.
I've seen his car. You wouldn't want it.
Just cars in general. In fact, that was the point I was trying to make in my initial argument, that it has never been understood that if a creditor is trying to replevy or foreclose on a security agreement that's duly recorded under Article 9 of the Uniform Commercial Code, Statute 679.109, which creates substantive rights. It's never been understood that when you go to replevy or foreclose a pure personalty security interest that's duly recorded, that you have to record a lease pendants or file a lease pendants in the case. Nobody does that when it's pure personalty. You only do it when the personalty, like I said, is associated with a hotel or a motel or other types of real property transactions.
Is it your position that Mr. Nelson's interpretation of the statute is incorrect?
Yes, it is, and Your Honor, it's glaringly incorrect. He keeps saying it's a penalty. Penalties under statutory construction should not be imposed unless the statute is very clear. You don't impose penalties, and I don't read 48.23 the way he does, that if you have a substantive right under another statute, which is the UCC one that's perfected, 679.109, that you lose that automatically as soon as you file to foreclose it and don't do something which no one has ever done, to my knowledge, which is file a lease pendants. So I would factor in the proper way to construe a statute which imposes the type of penalty Mr. Nelson is advocating. I also want to point out, he opened the door, talks about his intervention in my case, and I'm trying to intervene in his case. I mean, the ownership of these cases is interesting, but Judge Blackwell at the hearing, I did oppose intervention only because I wasn't allowed to intervene in his case, and he wouldn't agree. We would not agree either. I guess I was not, as we say, not playing tiddlywinks at a knife fight. So, Your Honors, Judge Blackwell at that hearing, she asked us.
No,
Yeah, okay, but there was astonishment. Okay. Thank you. Yeah, but in any event, I think the argument was unfair, and he was getting into things that were outside the record. The point that Judge Orfinger was making is the technical chemicals case, that we could not have intervened until after judgment. I think technical chemicals, which we've put in our brief, deals with that one of the considerations after judgment is, could you have meaningfully intervened before the judgment? And here we could not have. It was just a general collection action. We had no way of knowing about it. And frankly, I think they knew, as most creditors do, what assets you can seize or what you can't seize. It's been my experience in many years of practice that you don't go when you have a judgment and grab an asset which has a perfected interest in it without calling the creditor and finding what the payoff amount is, because otherwise you're buying something, or pardon me, you're levying upon something which isn't completely owned by the debtor. So I feel like I don't need to belabor this, and I do appreciate your time and consideration, and please do not establish the bad public policy that I think Mr. Nelson is asking you to do by asking you to rewrite the law of how one enforces a perfected security interest against pure personality. Thank you.
All right, thank you both.
Thank you.
All right, we'll go ahead and take up the final case for the morning, which will be Roberts versus Roberts.